大変お待たせいたしました。それではこれより、ヒューマンライツナウ主催イベント、ビジネスと人権、国連報告書が示す日本の課題と提言、これより開催いたします。私が本日司会を務めさせていただきます、ヒューマンライツナウ顧問、弁護士の西川研一です。よろしくお願いいたします。ありがとうございます。少し開催前に注意事項を申し上げます。画面に出ている通りです。まずですね、画面下の通訳を選択することで、同時通訳、日本語と英語ですね、そして手話通訳をご利用いただけますので、適宜ご利用ください。そして質問コーナー、後ほど申し上げますが、ご質問を会場もしくは Zoom 等で、受け付けることになっております。質問は画面下の Q&A、オンラインの場合は Q&A で随時受け付けておりますので、よろしくお願いします。なお、すべてのご質問にお答えできないこともありますので、この点はご了承ください。またですね、イベント中に接続トラブルなどもあった場合には、画面下の Q&A にてお知らせいただければ適宜対応をしてまいります。そして次のスライドですけれども、事前の許可なく、本イベントを録音、録画、そしてウェブ中継する等の行為はお控えを願います。後ほどですね、ヒューマンライツナウの公式 YouTube チャンネルにおいて、アーカイブを配信する予定であります。ですので、事前許可を得ていただいている報道関係者の方々におかれましても、手話通訳者等の撮影、録画、ウェブ中継は報道にはお使いいただけませんので、ご了承ください。そして、イベントの進行を妨害される恐れがある、また、イベント登壇者、主催者の心情を傷つけたり、誹謗中傷する恐れがあると主催者が判断した場合には、会場、オンライン問わずですね、途中で退席いただく可能性がありますので、あらかじめご了承ください。それでは、本日の、プログラムをご紹介いたします。本日のプログラムはですね、国連と皆さんご存知かと思いますけれども、国連のビジネスと人権、作業部会が、昨年、23年のですね、7月の24日から8月4日にかけて、日本国内で、訪日調査を行いました。そしてこれについての最終報告書が、2024年、先日の5月28日に、ウェブで公開されました。本日はですね、その中心的な役割になってこられた、ピチャモン・イエオファントン博士、この方を、お呼びして、この報告書の中身について、学び、そして議論していこうというイベントになります。それではプログラム簡単にご紹介しましょう。まず1番目、開会挨拶として、ヒューマンライツナウ副理事長弁護士である伊藤和子から開会挨拶をさせていただきます。そして2番目のパート、最終報告書を踏まえた基調講演として先ほどお話しいたしましたピシャモン・イエオファントン博士に、ご講演をいただきます。そして3つ目のパートで、対談質疑応答ということで、この他にですね、ヒューマンライツナウ事務局長弁護士の小川隆太郎、そしてヒューマンライツナウビジネスと人権プロジェクトオフィサーの山口悠佳も登壇させていただいて、会場からのご質問を受け付けて、議論をしていくという内容になっております。はい、スピーカーの皆さん、こういった方々ということになっております。それでは、最初の開会挨拶を、ヒューマンライツナウ副理事長弁護士である伊藤和子の方からさせてあげます。よろしくお願いします。
皆様、本日はお忙しい中お集まりいただきまして本当にありがとうございます。ヒューマンライツナウ副理事長の伊藤と申します。でヒューマンライツナウは2006年に発足をいたしました国際人権 NGO、日本を拠点とする国際人権 NGO として、活動しておりますが、一つの重要なエリアとしてこのビジネスと人権の問題ということに取り組んでまいりました。特に日本では国による人権侵害というのもありますが、国と企業が一緒になって個人を、ないがしろにするもしくはビジネスが利益のために 人権侵害を行う、もしくは人権侵害をですね、隠蔽するということが、長らく行われてきたということであります。でその中で多くの人たちが、虐げられてきたというのが日本社会だったのではないかというふうに思います。でそういった中ですね、2011年に国連ビジネスと人権指導原則というものが採択をされ、それを日本の中でも生かしていかなければならないという機運が、生まれてきました。で日本でも2020年にですね、この国連ビジネスと人権指導原則の国内行動計画というものが採択をされ、少しずつ進んできたのではないかというふうに言われていますが、それでもまだまだですね、表面的な実施にとどまっているのではないかということが指摘されてきました。でそれを、特にですね、ハイライトしていただいたのが、昨年ですね、この夏にですね、来日をされ、そして非常に重要な調査を、本当に丁寧に、日本全国各地に行っていただいて、調査をしていただいた、本日のピチャモンさんをはじめとする国連ビジネスと人権に関するワーキンググループの皆様だったわけなんですね。で昨年7月、8月にですね、皆さんも記者会見、かなりご覧になっていただいたと思いますが、特に本日もお越しいただいておりますが、ジャニーズ性加害問題のですね、当事者の方々が声を上げられた直後ということで、その問題についてかなりフォーカスをして取り上げられたというふうに思っております。でしかし、その問題も1年経っておりますが、十分に解決しているとは言えないというふうに私は実感をしております。今日はそのあたりのお話もですね、お話をしていただければと思います。でまたビジネスと人権に関わる問題は、このジャニーズ問題だけではなく、それは一つの、氷山の一角といいますか、他にも性被害であったり、ハラスメントで苦しんでいる方、差別に苦しんでいらっしゃる方がたくさんおりますし、さまざまなですね、福島原発事故であったり、技能実習生問題など、今回の報告書には、盛り込まれているものが、あります。そして日本全体を見ますと、やはり弱者を大事にしない、弱者をないがしらにしないようなそういったシステムですね、というものが根付いております。で今回のですね、報告書で私が一番ですね、非常に印象に残ったのは、この、差別の構造を解体しなければならないということを強くおっしゃったということなんですね。この報告書に書かれています。でそれほど国際社会から見て日本のですね、差別であったり弱い者をないがしろにする構造というのが大きいのではないかということを改めて実感する機会となりました。でこのですね、国連人権理事会のレポートですね、先週国連人権理事会に正式に提出をされまして、そこでですね、実際に私もジュネーブのですね、国連人権理事会に行ってまいりまして、討議に参加をしてまいりました。日本政府のですね、対応というのはなかなか十分なものではなかったわけですけれども、やはりこの勧告を受けて私たちがこの勧告を理解し、もっとプッシュをしていくことで、政府の対応を迫っていかなければならないのではないかというふうに痛感をしているところであります。でそういったこともありまして、本日は記者会見ではなく、一般の市民の方も含めてご参加をいただいて、皆さんによくこの勧告内容、報告書の内容を知っていただき、ぜひ力にしていただいて、現状の問題点を変えていただく、そういった機会になればというふうに思っております。後半ではですね、質疑応答の機会も設けておりますので、ぜひ皆さん最後までですね、いろいろなご質問もしていただければというふうに思っておりますので、本日はどうぞよろしくお願いいたします。そして、ピシャモンさんですね、オーストラリアからわざわざこのためにですね、来ていただいて、本当に熱心に日本の問題に取り組んでいただいておりまして、私からもですね、心から感謝とですね、敬愛の念を示して、私からの挨拶とさせていただきたいというふうに思います。ぜひ本日はピシャモンさんのお話をみんなで学ぶ機会にできればと思いますので、どうぞ最後までよろしくお願いします。ありがとうございました。
ありがとうございました。それでは、いよいよメインの、基調講演に入っていきます。最終報告書を踏まえた基調講演として、ピチャモン・イエオファントン博士に、基調講演をいただきます。ピチャモン博士はですね、2022年、国連の 人権理事会から独立専門家として任命され、アジア太平洋のメンバー、委員ですね、責任委員として国連のビジネスと人権作業部会で活躍をされてこられておられます。そして同時にですね、オーストラリアのキャンベラにありますディーキン大学未来防衛国家安全保障センターの研究部長も、研究職として務めていらっしゃるということになっております。本日はですね、報告書、最終報告書の主な内容、そして、日本におけるビジネスと人権の、日本政府、そして企業の取り組みの現状、それから提言などについてお話をいただきます。少し注意事項なんですけれども、そこに出ておりますよ、スライドにも出ておりますように、通訳ボタンご利用いただければということと、そして次のスライドをちょっと出していただけますか。はい。こちらの方の QR コードからですね、この国連に対しての最終報告書ですね、これがダウンロードして見ていただけるようになっております。英語原文は発表されたものですけれども、日本語版の方はですね、ヒューマンライツナウとビジネスと人権リソースセンターで、仮訳を行ったもので、国連発表の正式な訳ではありませんが、ご参考にいただければと思います。はい。それではよろしくお願いいたします。
Konbanwa, good evening, everyone. Thank you very much for being here. I understand that we have simultaneous translation into Japanese and, of course, into sign language. So I'm going to try my best to speak as slowly as possible. Thank you very much for the kind introduction. And of course, thank you so much to the organizer of this event, Human Rights Now, for inviting the UN Working Group on Business and Human Rights to speak with all of you today. It's an incredible opportunity to be able to share our findings, the insights from our report here in Japan, and to be engaging once again with stakeholders, many of whom we have engaged with before and who were so generous in sharing their insights with us today. And I note in particular the colleagues sitting in the front row alongside others who have contributed again so generously to our report. So the reason why I'm here, obviously, is because our report on our country visit to Japan was formally presented to the Human Rights Council just a week ago. And this is a very opportune moment for all of us, because it is an opportunity for all of us to be working together to accelerate the implementation of the UN Guiding Principles on Business and Human Rights. And it's always nice to be back here in Japan. It has been especially encouraging to see how active the public discussion on business and human rights here has become following our country visit last year. It goes without saying that Japan and its peoples possess numerous admirable qualities and an even stronger commitment to protecting and respecting human rights, particularly of those most at risk of business-related human rights abuses, would help with consolidating the country's reputation as a leader when it comes to exemplifying and safeguarding the rules-based global order. Even so, the task of protecting and respecting all human rights is never an easy one. You can ask any human rights defender, some of whom are present in this room, and they can tell you that it often feels like an uphill battle. A lack of awareness of business and human rights issues, combined with a reluctance to acknowledge problems and failures, among other factors, can contribute to, as well as amplify, the challenges that victims of business-related human rights abuses and human rights defenders face. But Japan is not alone in facing such challenges, as there are many other countries that encounter similar challenges. But it is important for Japan as a society to collectively face these challenges directly and transparently so that you can move forward and affect the positive change required to build a more inclusive, sustainable, and secure future where no one is left behind. Following this, I would like to acknowledge the presence of victims of business-related human rights abuses, together with the human rights defenders and business and human rights practitioners present at this event in person and online today. They deserve to be applauded for their tireless efforts to raise much-needed awareness to advance the implementation of the UN Guiding Principles on Business and Human Rights here in Japan. As I've said elsewhere before, it takes an incredible amount of courage to speak out about business-related human rights abuses, especially when you have endured such abuses firsthand. It also takes a huge degree of mental fortitude to constantly advocate for change when the odds aren't exactly in your favor. And so again, I applaud and commend on behalf of the working group all of those who are fighting tirelessly to ensure that the human rights of all are being protected and respected. Now, having said this, I would like to take this opportunity to do three things. First, explain who we are, that is, who the working group is and what we do. Second, to highlight some of the findings from our Japan country visit report. And third, to underline the key recommendations for the government and for businesses operating here in Japan to accelerate the realization of the UNGPs, the guiding principles on business and human rights. So first, a few words about the working group on business and human rights and the UN guiding principles. Some of you may already know, but we are comprised of 5 members, including myself, obviously, of balanced geographical representation. As independent experts who work as part of a fact-finding and monitoring mechanism of the UN Human Rights Council, we hold the mandate from states to promote, disseminate, and implement the UN guiding principles on business and human rights. Adopted unanimously in 2011 by the Human Rights Council, the guiding principles set out the duty of states to protect human rights, the responsibility of all businesses to respect human rights, and the need for effective access to remedies. The guiding principles are predicated on the human rights standards contained in and the principles derived from the Universal Declaration of Human Rights, to which Japan is committed and under which Japan has clear obligations to protect human rights. Indeed, the fundamental human rights guaranteed in Japan's own constitution echo the Universal Declaration of Human Rights. Under the UNGPs, all businesses, including state-owned enterprises and investors, have a responsibility to respect human rights. And when we say respect human rights, this isn't just about conducting, let's say, corporate social accountability, as in building hospitals or subscribing to the UN Sustainable Development Goals. Respecting human rights means actively preventing and addressing the potential and actual adverse impacts on human rights due to business activities and relationships. It is about respecting human rights by conducting what we call human rights due diligence, or HRDD. Indeed, at the crux of the guiding principles are human rights due diligence, the smart mix of voluntary and mandatory measures, and the use of leverage to compel rights-respecting behavior among businesses. Human rights due diligence in particular has increasingly become a focus for businesses globally as mandatory HRDD trends in Europe and elsewhere spotlight the importance of human rights due diligence to addressing business-related human rights issues. The working group's mandate on business and human rights is fulfilled through our engagement in a range of activities, including conducting country visits, issuing communications, and convening the UN Annual Forum on Business and Human Rights in Geneva each year. As the audience here will be aware, the working group visited Japan from the 24th of July through to the 4th of August last year, at the invitation of the Japanese government. The aim of the visit was to assess the business and human rights situation in Japan, in particular, the implementation of the UNGPs. The visit included consultations with government officials, businesses, civil society representatives, and members of at-risk groups in order to understand the efforts and challenges in Japan in relation to business and human rights. Here, the working group reiterates our abiding thanks to the government, to the business community, to civil society, trade unions, and all other stakeholders, including victims of business-related human rights abuses, for sharing their insights and experiences with us. At the end of last year's visit, we produced an end-of-mission statement with preliminary findings, which has served as the basis for this country visit report. Accordingly, I would strongly encourage for our country visit report to be read in tandem with our end-of-mission statement. And with respect to how our country visit was conducted and how our report was compiled, the working group followed the UN's Special Procedures Manual of Operations and Code of Conduct. The information contained in our report was carefully triangulated for factual accuracy, including through multi-stakeholder consultations that were held prior to, during, and after our country visit. The government of Japan had multiple opportunities to engage with the working group and provide information on all topics covered when reviewing, including when reviewing our draft report. As seen on the working group's website, the government has since provided public comments in response to our report. There will be no amendments, just to be clear, however, made to our report, noting that it has since, of course, been officially presented to the Human Rights Council. As our report points out, it is imperative that the government of Japan engage meaningfully with victims of business-related human rights abuses, communities impacted by business activities, civil society, and of course, businesses themselves. Doing so would allow the government to gain enhanced insights and understanding into the many issues and cases that were shared by stakeholders with the working group. In fact, the need for meaningful stakeholder engagement and dialogue was a recurring issue raised during our consultations and subsequently in our report. So let me now turn to some highlights from our report. We welcomed the important advances by the government of Japan in relation to business and human rights, including the fact that Japan is the second Asia-Pacific country to develop a national action plan on business and human rights. The guidelines on respecting human rights in responsible supply chains is moreover a positive development in terms of rendering even more practical the government's guidance on guidance to businesses. Indeed, the working group looks forward to seeing a second national action plan being issued in the near future. While noting these positive steps, the working group also expressed concern about the systemic human rights challenges that Japan continues to face, particularly in relation to deeply embedded harmful social and gender norms that can manifest in the form of workplace discrimination, harassment, and marginalization of at-risk groups. These concerns are yet to be adequately tackled as part of state and private sector initiatives in the business and human rights space. For example, there is still a need for discrimination legislation that incorporates a clear and inclusive definition of discrimination itself. We also observed a general lack of domestic awareness of the guiding principles and the National Action Plan, especially outside of Tokyo. There is more work to be done in this regard to ensure that all stakeholders, all relevant actors, including local governments, businesses, and business associations, trade unions, civil society, communities, and human rights defenders, to ensure that they understand the guiding principles and the commitments of the government under the National Action Plan. The second National Action Plan process therefore proves to be an important opportunity for the government to fully engage with all relevant stakeholders and enhance the transparency of the second plan's implementation. As the primary duty bearer, the government plays a critical role in protecting human rights and setting clear expectations for businesses to respect human rights throughout their operations at home and abroad. As per the guiding principles, it is necessary for the government to ensure policy coherence between human rights obligations and actions with respect to business, as well as with respect to developing robust legal frameworks, including mandatory human rights due diligence. Mandatory human rights due diligence measures are necessary for complementing voluntary guidelines as part of the smart mix advocated by the guiding principles. The working group further noted the government's opportunity to strengthen efforts among state-owned enterprises to implement the guidelines and, by extension, the guiding principles. Equally important is the need to ensure accessible and suitable judicial and non-judicial grievance mechanisms to enhance access to justice and access to effective remedies. In relation to our findings related to the corporate responsibility to respect human rights, the working group found significant gaps in understanding and in the implementation of human rights due diligence across value chains, particularly when these value chains traverse conflict-affected situations, and especially when they involve small and medium-sized enterprises. Small and medium-sized enterprises, or SMEs, contribute considerably to Japan's economic activity, but often lack the resources and guidance needed to conduct human rights impact assessments. They therefore need more support from their corporate peers, as well as guidance from government. Furthermore, we observed how increased efforts are needed to encourage the uptake of the guiding principles by general trading companies and retailers, which are especially well positioned to exercise their leverage in a variety of sectors. Certainly, there is more that the business community here needs to do in order to support the implementation of the guiding principles and ensure rights-respecting behavior across the business community. Our report identified how the myriad challenges faced by at-risk stakeholder groups, including women, LGBTQI+ persons, persons with disabilities, indigenous peoples, minority groups, including Buraku communities, children, and older persons, relate to the lack of diversity and inclusion in the labor market on the one hand, and the prevalence of discrimination, harassment, violence in the workplace, and exploitation on the other. Beyond the moral imperative to ensure inclusion, it warrants note how inequality can be economically and politically damaging. And so, to achieve sustainable growth and to leave no one behind as per Agenda 2030, it is important for business activities as well as government policies to champion inclusion and social justice by reaching at-risk peoples who are often those furthest behind first. In light of this, the working group's report considered the various stakeholder groups at risk of business-related human rights abuses. It noted with concern, for instance, the persistence of the gender wage gap, as well as the sexual harassment faced by women workers in Japan, and how there is a real need to promote gender equality and diversity in leadership and in the workplace at large. In relation to LGBTQI+ persons, the working group expressed concern about instances of discrimination and gender-based violence faced by this group, including in the form of hate speech. The positive developments that we have witnessed to promote gender equality and inclusion by the government and businesses here should, of course, be continued and accelerated, but these are issues that deserve to be prioritized even more. The working group also noted pressing challenges concerning the inclusion of persons with disabilities in the labor market and workplace. Minority groups, including Indigenous peoples, as well as older persons and children, likewise face a lot of challenges. We were struck, for example, by complaints regarding how workers with disabilities were being subject to false and proxy employment, whereby businesses provide a venue for work for persons with disabilities to fulfill another business's employment obligations. We observed major concerns regarding the treatment of ethnic Korean and Chinese workers, specifically the hate speech targeting them, as well as the discrimination suffered by Buraku people. We also emphasized the importance of protecting and respecting the rights of Ainu people as one of Japan's indigenous peoples, who have likewise been subject to discrimination, hate speech, and distorted representation. With respect to children and older persons, we stressed the necessity of mainstreaming children's rights in the context of business and human rights, and of spotlighting the labor rights of older persons to prevent exploitation. For our report, the working group further examined key thematic areas of interest. We did so by probing specific cases that are emblematic of the many serious concerns repeatedly raised to us by stakeholders. These range from the cases of PFAS contamination, the redevelopment of the Meiji Jingugayan, through to the Fukushima Daiichi nuclear disaster, the treatment of migrant workers, and human rights issues in the media and entertainment industry. And so I will now turn to summarizing the key points from each case. During the visit, our visit last year, the working group observed weak levels of awareness of the interconnection between human rights and the environmental impact of business activities. The working group stresses that businesses have the responsibility to respect human rights, and this includes the right to a healthy, clean, and sustainable environment. And so let me emphasize here again that protecting human rights and the environment, that the two are inextricably linked. Accordingly, all stakeholders need to work together to uphold human rights, environmental sustainability in the context of the climate change disaster. And all stakeholders must do so in order to prevent a siloed or stovepiped approach to protecting human rights and the environment. Specifically, in relation to the Fukushima Daiichi nuclear disaster, the working group was alarmed to hear that some workers of the subcontractors of the Tokyo Electric Power Company were forced to work on the decontamination and the decommissioning of the nuclear power plant to pay off debts. We were also concerned to learn that the company had 5 subsidiary layers of subcontractors, with workers on lower tiers of the subcontracting ladder reportedly receiving lower wages while performing the same job. The working group was furthermore deeply concerned to learn about workers who had developed cancer-related illnesses after their cleanup and decontamination work, but who had been denied financial compensation or medical assistance by the company's subcontractors, as employment records did not accurately reflect radiation exposure. These are but 3 examples out of the many other problematic practices that we heard in relation to the aftermath of the Fukushima Daiichi nuclear disaster. Many of these examples spotlight the need for effective remedies and also the need to celebrate the Fukushima Daiichi decontamination workers as heroes for the sacrifices that they have made. In relation to the issue of PFAS contamination, we heard of several cases of water contaminated with per and polyfluoroalkyl substances, or PFAS, in Tokyo, Osaka, Okinawa, Kanagawa, and Aichi, and these are reportedly linked to business operations. The working group notes the link between PFAS and negative health effects, which has also been previously highlighted by several special procedures mandate holders. And so, even though the working group notes the steps that have been taken by government and by the local governments to address this issue, additional measures are still needed at the national level to address PFAS contamination and its negative health effects in all affected regions. Given that PFAS contamination in these cases is allegedly linked to business operations, the working group highlights the business responsibility as well to addressing this issue under the guiding principles and the polluter pays principle. Transparency in the disclosure of information related to PFAS is very important in this regard, as is the conduct of meaningful stakeholder engagement to better understand the severity as well as the scale of the problem. With respect to the thematic area of labor rights, the working group examined how a range of labor-related human rights issues, including overwork, occupational health and safety, and the ability of workers to unionize, continue to be challenges that Japan faces today. In relation to labor unions, for instance, the working group received information concerning arrests and prosecutions targeting labor union members, including in places like Osaka. These members faced legal action under charges of the alleged forcible obstruction of business and attempted extortion, because they had participated in daily union activities focused on advocating for corporate compliance with laws and regulations. Labor unions are essential in promoting fair and lawful workplace practices. They help, in other words, to ensure that business enterprises respect human rights. And therefore, we reiterate the importance of labor unions being able to carry out their activities in a legitimate manner. With respect to the issue of overwork, which I believe many people here are already familiar with, the working group was notified about long-standing challenges associated with karoshi, or death by overwork. We noted as well the positive efforts made by the government to address this issue, as seen from laws enacted aimed at raising awareness, capping overtime hours, and preventing workplace harassment. We remain concerned, however, by reports of increased compensation claims involving work-related illnesses, which may suggest to continuing elements of this karoshi culture. And then in relation to migrant workers and the technical intern training program, the working group met with foreign workers under the technical intern training program, their employers and businesses whose value chains involve the use of workers from this program. It is important to note here that these workers constitute the second largest category of foreigners in Japan in 2022. And so while the stated purpose of the technical intern training program is resource or human resource development, these workers also play an indispensable role in addressing the country's labor shortage and in stimulating the economy. And so it was with concern that the working group heard cases of foreign workers being fired after suffering from workplace accidents and thus having their medical treatment discontinued. We also received reports of workplace violence, cramped living conditions, difficulties opening and gaining access to bank accounts, payment of exorbitant fees to agencies in workers' home states, among many other issues. We understand, of course, that the government, alongside other stakeholders, businesses, civil society, have been active in addressing these issues. And this is something to be welcomed, and it must continue. We were also interested to learn in relation to the case of migrant workers and technical trainees that the human rights bodies of the Ministry of Justice has opened up opportunities for human rights counseling services in multiple languages to foreign nationals and have also carried out awareness raising activities. This is one example of a positive development in order to address this issue. And it's also one that needs to be replicated in other issue areas as well. And this is because access to remedy, as we will turn to look at in even greater detail in relation to the case of the media and entertainment industry, is extremely important to ensuring compliance and observance of the UN Guiding Principles on Business and Human Rights. As some of you may have heard before, justice delayed is justice denied. And in the case of many victims of business-related human rights abuses, the legal system here can take a very long time. And so the longer it takes for victims to receive remedy, the longer it means that the injustice that they've had to bear becomes more and more of a burden for them, as well as their families and the people around them. And so it's with this point in mind that I now turn to the case of the media and entertainment industry. The working group observed deeply troubling issues within this industry. And we spotlighted in particular the idol and the animation sectors. We note how the animation industry here in Japan has seen a significant increase in profits over the years, and how this industry, of course, is one that has generated a lot of positive reputation for Japan abroad. Many people are fans of anime and of manga, and I include myself as one of those individuals. And so it was surprising and concerning for the working group to hear how there are major disparities when it comes to those employed in the industry as freelancers or independent contractors, and who were reportedly not receiving protection under the current labor laws. What this enables are excessively long working hours, as well as the perpetuation of unfair subcontracting relationships. And yet, animation production companies, along with their subcontractors, face no penalties. We were also alerted to how creators were often required to sign contracts that inadequately protect their intellectual property rights. And this creates an environment ripe for exploitation. Combined with a major labor shortage in this industry, the working group notes how imperative it is for businesses operating in the sector, including anime production committees, to address these issues and exercise leverage to enhance decent work for animators and prevent the potential collapse of this industry altogether. Similarly, in the idol industry, the working group was informed about young talents being coerced into signing contracts, obliging them to comply with every demanding requirement of producers, advertisers, and agents, while subjecting them to exorbitant penalties for non-compliance. Overall, this alarming environment fosters a culture of impunity and exacerbates sexual violence and harassment, among other problems within the broader environment. The working group was also informed about the sexual harassment and abuse suffered by female journalists, for instance, and the lack of remedial action taken by broadcasting stations. Key businesses, such as broadcasting stations, publishing companies, and advertising firms, they are all failing to uphold their responsibility to respect human rights because they are failing to prevent sexual abuse, and they are not sufficiently using their leverage to address in their business relationships to address these many human rights risks. The working group, as we have said elsewhere before, and in our report, continues to remain profoundly alarmed by the sexual exploitation and abuse involving the several hundred talents signed with what was formerly known as Johnny and Associates and which is now known as Smile Up. As noted in our end of mission statement, as well as in our report, media companies in Japan were implicated in covering this scandal for many decades, and it is now very positive to see how there have been various actions taken by businesses associated with Smile Up to take on greater accountability. Even so, there is still a very long road ahead for the victims who have suffered in this case. And we would also like to emphasize how disengagement is sometimes the easier way forward, but it is important, or in some cases more important, for the businesses associated with Smile Up to ensure that the company is operating in line with the guiding principles too. Since the working group's visit, we note how Smile Up has extended compensation offers through its remediation committee to hundreds of victims so far. But we are also aware that these compensation offers are inadequate in some cases or are still being processed. Noting what we had stated in our end of mission report, access to effective remedy means ensuring access to timely and appropriate remedy. And the nature of such remedy needs to be designed in collaboration, in consultation with the victims themselves. And so it is important that Smile Up continues to engage in this compensation process in consultation with the victims and to ensure that effective access to remedy is provided in their case. We also would like to note that in addition to the issue of compensation, it is also important to ensure that the problems we see in this case do not recur. And so recurrence very much needs to be a subject of discussion for us today and into the future. What it means to prevent recurrence will need to be something that we discuss, or that is discussed rather, in collaboration, in consultation with victims. But one step that can be taken is to ensure that there is adequate legislation in place to protect children's rights, especially when they are working underage. The working group understands that there are efforts currently underway in relation to such legislation. And it is important that at the heart of such legislation is the prevention of the further victimization of children who suffer from such abuses. And at the end of the day, the key message here is that children must be protected at all costs. One final thematic area that the working group looked at concerned the regulation of value chains and finance. We noted how in our meetings with representatives from business, government agencies, state-owned enterprises, and civil society, many of whom can operate or find themselves operating in high-risk contexts, including conflict-affected areas, how in those meetings, these stakeholders underscored the importance of guidance and practical measures to encourage heightened human rights due diligence. Stakeholders also informed the working group of the need for updated legislation and improved implementation related to transparency and information disclosure, as well as for grievance mechanisms for human rights disputes outside of Japan. In many instances, it is difficult to establish to what extent Japanese businesses and state-owned enterprises operate in conflict-affected areas. But we know, of course, that there are cases in Myanmar, in the Russian Federation, in Ukraine, that continue to occupy news headlines. And so in order to ensure that these operations in these countries align with the guiding principles, the very first step that must be taken is to ensure that there is transparency in information and in the information being disclosed. It is also important, as said earlier, that there needs to be the conduct of heightened human rights due diligence, which means that businesses operating in such contexts must constantly update the potential and actual impacts, adverse impacts that they can have on human rights in those countries. The working group also heard concerns related to forced labor along Japanese supply chains, such as operations linked to the forced labor of ethnic minority Uyghurs, or trafficking in persons, including children, for purposes of forced labor in tobacco farms in Malawi. These are of great concern, and they are issues that we as a working group are aware that the Japanese government is currently trying to tackle alongside businesses. Again, we need heightened as well as accelerated efforts in this regard. And this is especially the case when considering that globally, we are seeing the issue of value chains become an issue of great concern and an issue subject to legislation such as the European Union's Corporate Sustainability Due Diligence Directive. And so with that, I would like to turn finally to one of the key recommendations that we put forward in our report, and which we will continue to put forward in our further engagements. And that is the point about establishing an independent national human rights institution in Japan. The working group believes that the establishment of an NHRI, or National Human Rights Institution, here in this country would serve to address many of the issues identified in our report and which I have reiterated again today. A national human rights institution would also help to close a significant gap in state-led efforts to promote business respect for human rights and enforce corporate accountability. Currently, Japan is one of a very small few of countries in the world that are yet to establish a national human rights institution. If there is a time for Japan to do so now, it is now. We believe that many of the issues that we have encountered on our country visit could have been prevented with a national human rights institution in place. We believe that a national human rights institution can help to enhance transparency, information sharing, and learning of best practices when it comes to the implementation of the UN Guiding Principles on Business and Human Rights. And we also believe that such an institution needs to be independent so that it gains the most credibility and trust from stakeholders, especially those who are victims of business-related human rights abuses. Indeed, the working group identifies this as an opportunity for the government of Japan and for businesses in this country to address the continued lack of access to remedy for the cases of workers associated with Smile Up, who were victims of sexual abuse and exploitation, but also for workers involved in the cleanup of the Fukushima Daiichi nuclear power plant, who were employed by subcontractors, and for many others. If Japan were to establish a national human rights institution, this again could help not only with enhancing remediation of human rights abuses and violations, but also facilitate interagency coordination on human rights abuses and promote business and human rights understanding, awareness, and training for businesses, auditors, judges, public defenders, and other relevant stakeholders. Of course, establishing a national human rights institution is not going to become a panacea for all of the human rights issues that we see in this country. It is nonetheless a concrete step that the Japanese government can take with the support of the stakeholders that we have met, and of course, many others whom we have yet to meet. But if there is one message that I would like to convey to everyone here today and online, it's that the protection of human rights is a collective good. Having a national human rights institution will constitute a collective good as well. Indeed, advancing the implementation of the UN Guiding Principles on Business and Human Rights in Japan is critical, not only for consolidating the country's leadership in promoting human rights regionally and globally, but also for enhancing the positive human rights impact and competitiveness of Japanese businesses at home and abroad. The working group does commend the ongoing efforts to build capacity and raise awareness of the guiding principles and of the business and human rights agenda, again, as seen from Japan's National Action Plan and ongoing second National Action Plan development process. And we very much hope that there will come a day when we won't need to talk about the guiding principles anymore, because human rights will have become protected and respected by everyone and at all times. There are, of course, many other recommendations that we made in our report, and I would be very happy to discuss them with you in greater detail later in this event. But for now, we want to emphasize that it is very important for the government of Japan, for businesses, indeed for each and every one of us to listen to the voices of those who are most at risk. And it is important for us to recognize that human rights abuses, human rights violations are issues that should not be hidden behind closed doors, but in fact should be acknowledged and treated as soon as possible. And so until the day when the guiding principles are no longer needed because human rights are being respected at all times and by everyone, until then, we must work together to ensure that all of our rights are being protected and respected. And for the working group, we will continue to monitor the business and human rights situation here in Japan and in many other countries, and we remain committed to engaging constructively with all stakeholders. But ultimately, no matter what we as a working group do, the biggest task is with you, all of you, as Japanese citizens who care about human rights. The most important change, the most impactful change, will come from those of you in the room today and online and elsewhere who care not just about your human rights, but also the human rights of others now and into the future. And so with that, I thank you sincerely again for your time today and also for your attention to these human rights issues last year until this year. It has been very promising to see so many faces here this evening, and I'm sorry that I can't see those online, but your presence, your attention, your consideration to these issues will help to ensure, I am sure, a more shining and even brighter future for Japan and all of its citizens. So with that, thank you again, and I will hand back the floor to our organizers.
ありがとうございました。もう一度、ピチャモンイエファント博士に拍手をお願いします。それでは続きまして、第3のパートに入っていきます。対談と質疑応答ということで、ここからは先ほどの、ピチャモンイエファント博士、そして、ヒューマンライツナウ事務局長弁護士であります小川隆太郎です。よろしくお願いします。そして、ヒューマンライツナウビジネスと人権プロジェクトオフィサーの、山口悠佳です。よろしくお願いします。
私の
はい、皆さんこんばんは。今ご紹介預かりました事務局長の小川と申します。この後第2部としてですね、皆様の質疑応答も受け付けながら、ピチャモン先生からですね、この先ほどのお話も踏まえて、報告書の内容等をさらに伺っていきたいと思っております。で皆様の方、Zoom 参加の方はQ&A 機能の方で随時質問を受け付けておりまして、すでにいくつか質問もいただいております。また会場参加の皆様におかれましては、お手元に質問表として紙が配られているかと思いますので、基本的にはそちらの方にご記入いただいて、そちらをスタッフの方にお渡しいただければですね、こちらの方で適宜読み上げさせていただきます。ではい。でちょっとその質問が今皆さんがお書きになっている間、あるいは考えていらっしゃる間にですね、私どもの方からいくつかですね、質問させていただきたいなと思います。でまずすみません、私からなんですけれども、はい、今回のその報告書でですね、勧告について、これ国に対する勧告と、企業に対する勧告というのが大きく分けてありました。で国に対する、勧告については、全部でですね、アルファベットでいうと A から Y までですね、もうアルファベットを使い切るぐらい、数にして25個の勧告がなされていると。一方で、企業に対しては10個ほどの勧告がなされていて、いずれもかなり数としては多いなというふうに思うわけですけれども、これだけの数のですね、勧告がなされているということは、 大丈夫かな。他の国でもですね、同じぐらいの勧告がなされているのかということが一つ目のクエスチョンです。でもう一つはですね、これ国家がこれだけ25個も勧告を受けているということで、指導原則でいう国家の人権保護義務というのが、果たされていないという意味だと思うんですけれども、このことについて企業としてはどのように受け止めるべきなのか、つまりですね、決してその国が義務を果たしてないから企業も責任を果たさなくていいというそんな話ではないと思うんですけれども、企業としてやっぱこの国家が義務を果たしていないということについてですね、私なんかはやっぱこれは怒りの声を上げるべきなんじゃないかと思うわけです。例えば先ほどお話しあった国内人権機関が作られていないということについて、それによって、日本でですね、ビジネスと人権についての普及がなかなか進んでいないとか、さまざまな人権政策がうまく調整されていないといった実際問題が起きているわけなので、こうしたことについて、これまで我々市民社会として声を上げてきましたけれども、やはり企業もですね、一緒にですね、国に対して、この国家の義務を果たせという声を上げていくべきだと思うんですけれども、そういったその企業にとってこの国家の義務についてはどのように受け止めたらいいのかということ、その2点をお伺いしたいと思います。
So I will try to answer your questions as best I can, but perhaps you can let me know if there's anything else I can elaborate upon. So in relation to your first question about whether other states receive a similar number of recommendations, this is quite difficult to say. And the reason is that it varies from country to country. And so it might be dependent really on the nature of the issues, as well as the nature of the stakeholders involved in those issues. And so I would say, more or less, the level of the nature of the recommendations that you see here in our report are aligned with the ones that we provide elsewhere, where there is a focus on the obligation of the government to protect human rights and create an enabling environment for businesses to respect human rights, and also a set of recommendations to businesses on how they can better respect human rights as well. So in light of that, we followed a very similar structure to other reports that have been produced by us, and also the reports produced by other mandates in special procedures. But as to the number of recommendations, it's hard to say because, again, it varies from case to case. With respect to your second question, and if I understood correctly, it's about how we had focused quite a bit on the government. Right. Especially more so than the enterprises. And that's a good point to make, because you are right that we did end up focusing much more on recommendations to the government. And the reason for that is because the state is the primary duty bearer when it comes to protecting human rights. And as I've said before, the state or the government is the one responsible for creating an enabling, rights-respecting environment for businesses to follow. And so if we are going to see major change, it needs to start with the government. Having said that, it's also important for businesses not just to wait around for government to change or for legislation to change. There are examples that we as a working group have seen in other countries where businesses have taken the initiative to become rights respecting and to really advance measures on business and human rights. And we have also seen how in many cases, governments do listen to businesses too. And so here in Japan, I want to say that our engagement with businesses has demonstrated a willingness on their part to really push forward the business and human rights agenda. But aside from saying this in rhetoric or on paper, we need now to see even more action. And so it's in light of this that I think when you read our recommendations, it's best to look at them all together, so holistically, because one is difficult to happen without the other also happening. And so governments, businesses, civil society, everyone needs to be working together to advance business and human rights. Does that answer your question?
So I also have a question. So you have determined the at-risk groups, what kind of stakeholders there are. And so there are a lot of corporations that are participating today. How can corporations use this information of the determination of at-risk groups?
That is an excellent question. And I would say, again, this also depends to a certain degree on the context. And this is why, under the guiding principles on business and human rights, we tell businesses that it is important for them to conduct human rights due diligence. Because by conducting human rights due diligence, they will be able to more accurately assess the at-risk stakeholder groups that their business activities and relationships stand to impact. And so absent human rights due diligence processes, it is difficult for businesses to understand who exactly they might be impacting. As we say that businesses can have a direct impact or direct negative impact on human rights, but they can also be linked to or contribute to such abuses too. And so it's very important that businesses bear that in mind when they are conducting human rights due diligence, because it may well be that the stakeholder group that they think they're impacting might be more than just one. So I would say it's not a straightforward process, but it is one that needs to be done because it will help businesses in the longer term.
Thank you.
はい、ありがとうございます。だいぶ、Zoom の方からですね、Q が来てまして、最初の方でいただいている質問としてですね、神宮外苑の関係といいますか、パラグラフ57と、sorry. yeah, paragraph 57. で、日本の環境アセスメントにおけるその公衆協議と訳される、パブリックコンサルテーションですね、が不十分であるというような指摘がレポートの中に、あったかなと思います。環境の影響を評価するプロセスにおいて、住民との協議が不十分であるという報告について懸念を示されているという文脈においてですけれども、そこでですね、日本政府はこのパラグラフについて削除してくれというようなことをアンサーで言ってきたりということなんですが、結局この、こういった住民もそうですし、それ以外のステークホルダーとの、そういったダイアログがなかなか日本で十分なされてないんじゃないかという問題意識だと思うんですけれども、今他のところでもですね、多分出てくる話だと思うんですが、日本でやっぱり一番大きな問題の一つとして、我々が例えばその企業とステークホルダーダイアログをしようとしてもですね、なかなか意味のあるものにならないという問題があります。で、そういったのは国際的には今単なるステークホルダーダイアログじゃなくて、ミーニングフルなステークホルダーダイアログをしようということが言われていると思うんですけれども、じゃあそのミーニングフルっていうのは具体的にどうやったらいいのか、ちょっと一言で回答できないかもしれませんが、どういった考え方が今国際的には言われているのかといったところも含めてですね、でもしその関係でこの神宮外苑でのその住民との協議ということについて何かもしコメントがあればお願いしたいと思います。
Thank you for that question. And we, of course, understand that when it comes to understanding or determining what constitutes meaningful and effective stakeholder engagement, that this can be difficult. But if I can provide a concrete example of what is not meaningful stakeholder engagement, would be, for instance, organizing explanation consultations where the people listening don't really have a chance to say anything, or where they feel that what they say is not adequately being considered by the business that organized the consultation in the first place. And we see this as a recurring issue. Again, Japanese businesses aren't the only ones that are still grappling with this challenge, but it is nonetheless important for us to bear in mind that not all consultations are meaningful, as you were saying. And so meaningful consultation is something that has to be decided upon and arrived at through the active engagement and dialogue with those who stand to be most affected by the project or by the activities that are under scrutiny. In relation to the case of the Meiji Jingu Gaien, if I understood it correctly, is the question about the government of Japan's response to our report, and the fact that they had requested that the paragraph concerning this project be removed. As I said previously at the outset of my remarks, in conducting our country visit and in writing our report, we followed closely the UN's Special Procedures Manual of Operations and Code of Conduct. And the information contained in our report was carefully triangulated for factual accuracy, whether it be through multi-stakeholder consultations and through the reading and survey of trusted, credible scientific reports. And so there will be no changes made to our report. The contents that you see now will remain the contents in the foreseeable future. And so there's nothing more I think I can say beyond what I've already said, which is that we conducted everything in accordance with UN procedures. And while we respect the opinions provided by the government of Japan in document form, they also did receive an opportunity to provide comments throughout the entire country visit process. I think I'll just leave it there.
この、報告書が出された後も引き続き日本政府とのダイアログっていうのは行っているということなんでしょうか。
Yes, of course. We continue, that is what we are committed to doing, to communicating and dialoguing with the government and indeed with all stakeholders. And as I noted at the outset, we are also grateful to the government for inviting us to conduct this country visit in the first place, and also for the support and the insights provided by government officials throughout our entire country visit, and also to our report. And so there is no doubt that we remain very keen to engage with the government and really with everyone.
ありがとうございます。ちょっとそこも関連するかもしれないんですが、Zoom の質問としてですね、PFAS, sorry, it's about PFAS? 内閣府が先日指標を発表したということで、ただその指標は非常に緩いというんですかね、ものになっていて、その指標によると、この方の評価でヨーロッパ64倍のPFAS を含む水を飲むことが許されてしまうような内容ですといったことが起きましたということなんですけれども、こういった報告書が出された後に、この PFAS に問題に限らず、いろんなアップデートがあると思うんです。で、今日ご参加いただいている皆さんもそれぞれ、取り組んでいらっしゃる問題があって、報告書にもっとこんなことも載せてほしかったとか、あるいはこんなことがその後起きてますといったような情報提供したいというようなことがあると思うんですけれども、今回の報告書のフォローアップといいますか、この後何かそういった市民からの情報提供とかはですね、引き続き受け付けていらっしゃるんでしょうか。
Thank you also for that question. So even though we have already concluded our country visit, there are indeed avenues for further engagement. I said earlier that the working group will continue to monitor the business and human rights situation here in Japan. And to do so, we will, of course, value any insights, feedback, inputs that can be provided from the citizens of Japan themselves. And so one avenue of engagement would be, for instance, our communications procedure. This is a special procedures, basically a complaints mechanism that we have and where we can receive issues relating to human rights abuses from stakeholders. We have received many complaints or allegations before, and we continue to receive many from the Asia Pacific region. And so I would urge those who would like to raise further concerns in relation to PFAS or any of the other issues already covered in our report, or those that we have not heard about, to please take a look at the UN website to find more information about our complaints mechanism, because that is one valuable way for us to hear from you and for us to also assist you with raising awareness and gaining more information about the situation on the ground. Because what we do with that communications procedure is we send letters to government and to businesses involved in those cases. Another avenue for engagement would be through our annual forum on business and human rights. We have one in Geneva each year, and we also have regional forums, including one that will take place in September this year in Bangkok. And so this provides another opportunity for stakeholders to raise awareness about issues, challenges, or positive practices in relation to business and human rights. If you do have further questions about how to get in touch with the working group, you are very welcome to send us an email, which is available on our webpage. It's too long for me to repeat here, but if you do send an email, please just say that, whether this is a time-sensitive issue, an urgent issue, and we will do our very best to respond accordingly.
So I'd like to ask you a question that we got from before. So as seen as in the gender gap index, Japan is said to be a developed country, but the human rights awareness is weak. During your investigation, what did you think that is a problem peculiar to Japan?
That's another very good question, I must say. It's always hard to say that an issue is really peculiar to a particular country. At the same time, I mentioned at the outset of my remarks that the challenges, the structural challenges that we see here in Japan are not unique to just Japan either, right? But of course, we intentionally spotlighted in our report the issues around, the structural discrimination and the harmful gender and social norms that we see here in Japan. And I would say that those, to some extent, are unique to Japan because they are based on how Japan itself has operated until now. At the same time, I think when looking at the discrimination, let's say, of Ainu peoples or the Buraku community, those are pretty unique to Japan as well, because you don't really have the Ainu people anywhere else in the world, nor do you have the Buraku equivalent or the Buraku in other countries. So those are the immediate kind of unique elements that I would, and stakeholders who I would highlight. But I suppose what I want to say as well is that it's important for us to remember that, in relation to the media and entertainment industry, for example, we have heard of egregious human rights abuses, sexual exploitation and violence in other countries as well, whether it be the UK or the US. But if I'm being honest with you, it doesn't matter where these problems take place. The problem is that they are taking place and that they are not being duly treated or dealt with. And that's probably what I would like people here to please focus on. I do not want this to become, us versus them or the UN versus Japan, because that is not the intention of our country visit or the report that we have produced. We conducted our country visit, we produced our report because we want to help. We want to be part of the human rights community here in Japan, doing good things for people and for planet. And so I would encourage you to please consider framing these issues as collective goods issues, as collective problems that we all must solve, regardless of our ethnicity, our gender, or where we currently live. I, of course, appreciate the question, and I completely understand where you're coming from. But I think having seen and heard for many others who do not like us very much, if I can put it that way, it's just important for us to bear in mind that it's not an us versus them problem. It's not the UN versus Japan. It's not human rights defenders versus businesses. We're all in this together. We're working towards the same goals. And that goal is the protection of human rights, because that will benefit everyone.
じゃあ今、ちょっと今、すみません、さっきからズームの質問ばっか取り上げてたんで、会場の質問もと思ったんですが、ちょっと今準備してますので、ちょっとズームからの質問ももう少し拾いたいと思います。匿名の方からですけども、本日の講演を聞くまでは、昨年夏の調査がこのように多分野に及んでいたことを知りませんでしたということで、確かに旧ジャニーズ問題についての報道というのが当時ピックアップされて、それは重要な問題なんですけれども、それ以外にもこんだけ問題があったということを初めて知りましたという方がいらっしゃるようでした。でその方からは報道業界に対する調査もあったようですが、報道業界について対しての提言とか助言ありますかというご質問をいただいていて、ただこれまさにそのジャニーズの問題に絡んでくると思うんですけれども、ジャニーズの問題、もちろんスマイルアップの問題もあるわけですが、そこをサプライヤーとして使っていたですね、テレビ局ですとか、あるいはそれ以外の広告会社とか、そういったところのサプライチェーン上の問題とも位置づけられると思います。そういったそのエンターテインメントという先ほど業界の話がありましたけれども、特にそういった報道機関ですとか、広告業界について何かピチャモン先生の方から提言等ありましたらぜひ伺いたいと思います。
So thank you very much for that question. I will try to unpack the question and answer it bit by bit, but again, if anything is unclear, please feel free to let me know. So yes, you are right that the issue of Smile Up was one of many issues that we looked at. It is an issue that has received a lot of attention, and deservedly so, and a lot of concern as well. And as a working group, we have been trying to follow the news reporting on this issue. And we appreciate the attention that the media has given to this issue as well, especially when they speak directly to the victims to hear their voices and ensure that their voices are being raised and elevated so that they are listened to. In relation to what the media industry or the media and entertainment industry can do, I mean, obviously we spoke a lot, or I spoke a lot about compensation, and that is very important, but it is also important for us to ensure that there is no recurrence of the sexual abuse and exploitation that we see in this industry. As part of our thematic focus on media and entertainment, I noted in my remarks how female journalists, for instance, are also subject to sexual harassment, if not violence. I also noted how there are other parts of the sector where we see degree of child exploitation as well, or coercion of idols. And so as a whole, the media industry and the entertainment industry should use this opportunity as a moment for introspection and reflection. We have been following how the media itself has been representing the issue of Smile Up and how they have represented the victims themselves, because media depictions of victims have a huge impact on how a case is perceived. The working group notes, and indeed we note with grave concern, the harassment that victims in the case of Smile Up have faced as a result of them speaking up and speaking out. I have said this elsewhere before, but such harassment, whether it be online or in the real world, is plainly unacceptable. No victim should be subject to harassment. And so with that, I think it's important as well for the media and entertainment industry, along with the Japanese government, to consider how they can enhance access to remedy for victims, not just from this industry, but from all sectors, but also ensure that the safety of the victims are assured. It's not going to be easy, but I think with the amount of attention that this issue has been able to generate, that there is a hope looking forward. And I think for the media and the entertainment industry, it's important for all of you in this sector to think carefully about how your actions can have potential and actual human rights impacts. This again goes back to the point I made about human rights due diligence. And it is about anticipating the kind of issues that can arise, which you might not be thinking about now. I think the question also asked about disengagement, right, and using leverage. And it is very much the case that, when it comes to businesses that have conducted or have had a negative impact on human rights, that disengagement might not always be the first answer. Yes, there are instances when after having conducted human rights due diligence, disengagement might be the only answer. But until all options have been exhausted, disengagement might actually generate more human rights harms. And so I would say that this applies to the media and entertainment industry as well. Rather than pursuing disengagement all the time, whenever a problem arises, you as a business associated with the harm, you also need to consider the role that you have played. And you also need to take proactive efforts to address the issue. This includes by engaging with the business that is involved in the human rights harm. And it is also in relation to engaging with the victims themselves directly. So there are many things that businesses who are associated or linked to human rights abuses should be doing. This is at the heart of the concept of leverage seen in the guiding principles. So disengagement can be the answer at times, but it is usually not the first answer. And it should only be really the approach taken once leverage has been pursued.
ありがとうございます。最後の点、特に確かに重要なメッセージだったと思います。人権リスクがあるからといってですね、その取引関係を終了すると、直ちに終了するということが、必ずしも責任ある対応とは言えないということで、そういった対応がしばしば見受けられますので、日本においては、そこはぜひ我々も深刻に受け止める必要があるというふうに思います。続いてですね。
So there's another question that came in through Zoom. So they say, I feel that there are so many instances of the media not reporting and covering up human rights issues, starting with the case of the former Johnny's case. The lack of media coverage seems to prevent many people from seeing the problem. I think the major problem in Japan is that the connections between major advertising agencies, the government, and corporations are very strong. How has other countries resolved this problem?
That is a good question and a very big one. I'm not sure if I have the time to go into a detailed response to that question, but I will say this. I mean, for colleagues from the media and entertainment industry, I think you have heard now from the questions asked that people are wanting for you to take even more action. And I think it's this type of dialogue or this type of exchange that can be very beneficial, both in the short and the longer term. I feel like many of the problems that we see often emerge from a lack of transparency, a lack of understanding that there are responsibilities and obligations to human rights. And so with the discussions and the public debates that we as a working group have been seeing here in Japan, I feel like that is already laying a positive groundwork for more fruitful discussions, even more fruitful discussions about business and human rights, and the role that, again, the media and entertainment industry, but other industries also should be taking. So I'm not entirely sure I can go into great detail, but I would say that the working group has issued a report on the subject of corporate lobbying, or corporate capture, as we call it informally. And it's about how companies can participate responsibly and in alignment with the guiding principles and human rights, so that they can ensure that their engagement with policy-making processes don't result in adverse human rights harms. And similarly, the guidance that we offer is applicable, obviously, to governments. And so governments can look at our report on corporate participation in the policy-making process to get further insights into what can be done in order to prevent undue influence from companies in policymaking. I hope that goes to answering your question to some extent. It's a good one, and I think we need to continue ruminating on the problem and the potential solution.
はい、ありがとうございます。もうさ、今の話と絡むかもしれませんけれど、先ほどのお話の中で、とても大事だなと思ったもう一つの点として、今のその旧ジャニーズの被害者の皆さんの救済、グリーバンスのところで、必ずしも十分な内容になっていないということの一つの原因というか理由として、やっぱそのちゃんと被害者とコンサルテーションができてない。つまりそのステークホルダーダイアログができていないということがご指摘されてたかと思うんですけども、今の日本のその理解の中でですね、そのステークホルダーダイアログというのは、ある意味その人権デューデリジェンスをするときに、自分たちのそのサプライチェーンでどういったところに人権リスクがあるかということを、企業だけではなくて当事者からも話を聞いてマッピングして特定しましょうという文脈ではよく語られるんですけれども、UN ガイディングプリンシプルではやっぱそこはステークホルダーダイアログというのは全部のプロセスで重要だというふうになって、当然グリーバンスの部分でも被害救済の部分でもステークホルダーダイアログ、その被害者あるいはそれ以外のステークホルダーとの対話というのが求められているんだということがポイントで、そこが確かに今のこの日本の社会では少し抜け落ちてしまっている視点かなと思うんですね。なのでちょっとそのグリーバンスのところで求められるそのコンサルテーションっていうのは、ジャニーズの例もあると思うんですけども、もう少し一般的な話でも結構ですので、どういったコンサルテーションが国際基準としては求められているのかということで、その日本で調査されて、特にそのグリーバンスのところで、その特に問題だなと思ったことがあればですね、そのコンサルテーションのあり方として問題だなともし感じられたことがあれば、そちらも含めてご紹介いただけるとありがたいです。
Another good question. And another big one. Let's see. Before I answer, can I get a sense? Will we have time to get questions from the floor here?
Yeah.
They will send it through. Okay. I'm just mindful that we don't have a lot of time left, and I can end up answering for a very long time. But in terms of consultations, look, I said this previously, that there is no one-size-fits-all approach to meaningful consultation, right? It needs to vary on a case-to-case basis, because in one situation, it might be easy to reach out to the affected communities or the victims. In other cases, it might be more difficult because they might be fearful that their identities could be exposed, or it could be that they are located in very remote areas and you can't access them so easily. So there are many considerations that can impact how a consultation is held and how it can become meaningful as a result. But one of the things I think that we heard during our country visit here is how, sometimes consultations are organized almost like as a box ticking process. So it's not in order to really gain insight into the views of the stakeholders impacted, especially the communities affected or the victims themselves, but rather so that the business can fulfill their legal requirements to conduct consultation. And I mentioned earlier how this can be quite evident when you're sitting in a consultation room and it's just a one-way lecture, right? People are just listening there, absorbing the information, but don't necessarily have an opportunity to raise questions and be heard in that way. I've also heard about how businesses can put up consultation information on their websites and invite submissions and inputs on their projects through those means. But here we have to be mindful that not necessarily everyone has access to the internet at all times or has that online internet literacy. I'm thinking here not only of older persons, but even sometimes for someone like myself, navigating a website can be quite difficult. And so how you present that information and the medium that you use to disseminate that information are very important considerations too. If you are wanting to reach a community or victims who are children, for instance, and let's say you have a grievance mechanism set up, is your grievance mechanism accessible to those people? And I know, and I've heard from colleagues working on the Smile Up case, when they think about recurrence, they are saying things like, we actually need a mechanism that allows children to submit complaints even without the consent of their parents, because it might be difficult for them to disclose such abuses to their parents, but they also need to have their own avenue to express and communicate the experiences that they've had. So those are just some examples of the considerations that need to be factored in when designing a consultation mechanism. But I might just leave it there.
ちょっと難しい質問に答えていただきありがとうございました。次はもう少しシンプルな質問なんですけども、その東京とですね、東京以外とで国連指導原則あるいはNAP についての認識にギャップがあるというお話があったと思うんですけれども、特に東京以外で、そういった認識を NAP や国連指導原則に対する認識の向上をするために必要なことは何でしょうかという質問が来ております。
Well, I must say, I'm hoping that our country visit report will help jumpstart some of the business and human rights conversations in other parts of Japan. I'm hoping that the attention given to the issue by businesses, by civil society, and specifically by media will help to raise awareness and interest in these issues. I would say that's where it all starts. The issue that we saw with respect to awareness stems from the relative lack of communication about the guiding principles from the center here in Tokyo to other parts. In our report, we noted how, for instance, the Tokyo metropolitan government, the government in Hokkaido and elsewhere, that they are gaining awareness and interest in these issues, and there are initiatives that are underway. But I think it's also necessary for the governments at the provincial, at the local levels to be doing more work in terms of raising awareness with the local businesses operating in their provinces or prefectures and so forth. So to me, it starts with communication again. It starts with disseminating information about the guiding principles. And it starts with communicating with one another about the human rights or business-related human rights issues that we see in those different parts. Because an issue in Hokkaido will and probably will look different in Tokyo, and which may look different in elsewhere. So I think that's probably what I would say to that question, but it's a very good one to bear in mind, especially in view of the second National Action Plan on Business and Human Rights that Japan is currently in the process of designing.
Okay, so since the venue is at a university, there are a lot of university students. And regarding the guiding principles, Pillar 1 is the state's duty, and Pillar 2, the responsibility of corporations. But do you think, what can people like us, like, for example, university students do in regards to the issue of business and human rights? It's kind of a broad question, but yeah.
It's a very good one. I mean, I'd like to get a sense, how many students are there in this room by a show of hands? Okay, 3.
学生の方手挙げてください。もっと多分いますよね。
多分ね。In any case, great to see the 3 of you here. I promise I will not pick on you as I answer this question, but I will look at you because you are now officially representing the university students of Japan. Big burden, isn't it? Well, to that question, look, university students in general, at whichever level, play an incredibly important role when it comes to advancing understanding about human rights, business and human rights in particular, but also when it comes to taking action, right? The working group has engaged with a lot of youth groups in many different countries. And we have often seen, with no offense to other people in this room, that a lot of the times the energy and the passion comes from the younger generation, and it can be infectious. They have a positive cascading effect, I feel, oftentimes on other generations too. And so looking again to the 3 of you in this room as representatives of Japanese students, I would say, don't ever underestimate the impact that you as an individual or you as a community or as a group can have when it comes to these issues. I turn here to the victims who we have engaged with, and it has been very inspirational to see how their courage as individuals, but also as a group, have helped to spotlight a very big issue in relation to business and human rights here in Japan, but how that issue is now giving courage to other victims and other issues to speak out as well. And so I think this is an example of the power of the individual and the power of willpower itself. And so really the most I can say is, even though you are students, don't ever think that you are powerless. Don't ever think that you don't have a voice. And don't ever forget that you have rights as well. And that when you are fighting for rights now, you are also fighting for the rights of future generations. And so the responsibility in that sense that you are bearing right now is not just yours alone, but it is of those who are yet to come. It's a very abstract way of putting it, but we as a working group are very, very committed to working with future generations and to hearing also their concerns. And I think for Japanese society as a whole, listening to the voices of youth, of children, will be very important for the sustainable and inclusive development of your country and society.
.これも全部の質問なんですけども、NHRI ですね、国内人権機関について、先ほどとても重要であって、今こそ作るべきだというお話をいただいたかと思うんですけれども、 その特にこれ英語なのでそのまま読んじゃいますけど、through your experience in preparation of the report, what opportunities do you and colleagues at UNWG see in establishing NHRI in Japan? In addition, what is your recommendation for an effective and functional NHRI that is suitable in Japanese context? ということで、もしもう少し具体的に日本で国内人権機関を作るとしたら、どんなふうに作ったらいいかということについて何かコメントがあればいただけますでしょうか。
Another very, very good question. What I can say, because it's a big one, and it would take me time to go through the Paris principles in relation to how to build a good national human rights institution. I would say that the first step is to really, for Japan as a whole, to be discussing what creating a national human rights institution would entail and what such an institution would need to look like. In terms of the Paris principles, one of the key characteristics of a good NHRI, or National Human Rights Institution, would be its independence. And we see in many different countries how this is not always an easy feat to achieve. There are NHRIs in other countries that, even though they exist in name, they don't always fulfill their functions, or they are not always truly independent from whether it be government or business influence. And indeed, there is a ranking for the quality of NHRIs globally that people can consult. So for the working group, and this is something that we stress in our reports and in our engagements thus far, an independent national human rights institution is very important, with the emphasis there on independent. If I'm not mistaken, I went through some news reporting recently on this issue of NHRIs here in Japan, and I was pleasantly surprised, and I felt a degree of hope to see that the Ministry of Justice, for one, has indicated that it is now thinking again about a national human rights institution. I'm paraphrasing here what was in the actual news report itself, but I understand that can I put it as a struggle, or the desire for a national human rights institution and the effort surrounding it has been ongoing for a decade or so now here in Japan. And so again, it's about time that we see it happen now. And I think the discussion has matured even more so than a decade ago for Japan and relevant government agencies to be dialoguing amongst themselves, but also with civil society in this case, to get a better understanding of what a good independent national human rights institution should look like for this country.
ありがとうございます。たくさん質問いただいていて、必ずしも全部取り上げられなかった部分もありまして、その点は申し訳ないんですけども、おおむねいただいた質問のテーマとしてはカバーできたかなと思うんですが、今回、この2024年にですね、こういった形で訪日調査のレポートをいただいて、我々日本人にとっては大きな宿題をもらったなという感じがしています。ここに書いてある包括的な勧告をですね、これから一つ一つ実現していく必要があるということかなと思うんですけれども、もちろんそれを進めて皆さんと一緒に進めていきたいなと思うわけですが、これ可能性としてですね、こうやって頑張っていきますけれども、また、数年後にまたこういった形でカントリービジットっていう形で来ていただいて、その時点での進捗をまた評価していただくといったようなことは例えばできるんでしょうか。なんかそういった今後に向けて私たちがこの報告書に書いてあることを実現していこうというときにUNG 作業部会としてどういったサポートがいただけるのか、あるいはどういった手続きが利用可能なのかということを最後アドバイスいただければと思います。
Just wanted to make sure it was a question. Well, it's a good question because yes, it is possible for the working group to conduct a follow-up country visit to Japan. we usually do so after a certain amount of time has already elapsed, or if there is a major human rights issue that has happened and which we would like to better understand and investigate. But the short answer is yes, it is possible to do a follow-up visit. To go back to something I said earlier, though, it's not only through country visits that we can help inform the discussions and that the working group can get, inputs on human rights issues here from Japan. There are many other mandates as well, aside from business and human rights, who are interested in looking at human rights issues here in Japan. So altogether, as special procedures, we're always very keen to engage in things like academic visits, which is what I'm doing here right now, or indeed through our communications procedure, so receiving complaints from stakeholders about human rights abuses. So please don't think that it's only through a country visit that you can have, that you can dialogue with the working group or with special procedures and have an impact. I should hope that, you will have an impact with or without us, but also there are many other ways for you to engage with us in order to do so. So I hope that answers your question. But look, we know that the issues that we have raised in our report are many. We know that these are issues that are very serious, and that they will not, unfortunately, result in immediate fixes. But we, as a working group, genuinely hope that our report will serve as a basis to inform Japan's second national action plan on business and human rights, but also inform the broader public discussions and consciousness about business and human rights. So it's, as you were saying, it's a lot of homework.
Yeah.
And the difficult task now lies with each and every one of you and with Japanese society as a whole and with the Japanese government as primary duty bearer to ensure to the best of their abilities that the human rights issues that we have raised with the inputs from many stakeholders will finally be addressed with effective remedies and resolutions provided to those who have been victims and to those who have been affected.
ありがとうございます。そうしましたら、時間が参りましたので、こちらで第2部のQ&A と対談のコーナー終わらせていただきたいと思います。皆様、どうもご協力ありがとうございました。
ありがとうございました。それではこのままの状態で最後の閉会の挨拶を、事務局長の小川隆太郎の方からお願いします。差し上げます。すみません。
すみません、そうです。私、閉会の挨拶もするんですね。はい、もう最後にピチャモンさんからもご挨拶いただければと思いますので、私、じゃあ、先にすみません、最後の挨拶をすみません、いただければと思います。
Oh, thank you. It's me again. Look, final words. Firstly, I'm sorry that we weren't able to hear from those of you in the room today. What I will ask is whether the organizers can help to forward the questions and the comments that you have made through to myself so that I can share it with the rest of the working group. So that way, you can rest assured that we will be hearing from you. The other thing that I will say, and this follows on from what I said earlier, is that I hope that our report results in positive change for this really, really wonderful country. I know all of my colleagues on the working group feel the same. We wouldn't be coming to Japan, really, if we didn't think that there was hope for the future. And we wouldn't be coming to Japan if it weren't because of the government's invitation. So if we combine those two considerations together, I think that actually paints a fairly positive picture. The government presumably wouldn't have invited us if they didn't think that the business and human rights is an important issue. And similarly, the businesses that we engaged with presumably wouldn't have engaged with us if they didn't think that business and human rights wasn't an important issue. And so I hope that the goodwill that is there and the goodwill that we've seen here today will continue to help develop and support the very much needed dialogue in human rights in this country. And most importantly, perhaps, I hope that the ongoing situations, whether it be in relation to Fukushima, PFAS, and many other issues, migrant workers, the media and entertainment industry, we as a working group sincerely hope that these issues will be resolved and that the voices of victims will be heard and that victims themselves will no longer be subject to harassment or to hate because they do not deserve that. If anything, as I said before, victims who have spoken out about these issues deserve to be applauded for their bravery and for the fact that they have persevered for so long without much support at all and are now willing to take the step into the light so that we as a society can together develop and improve the human rights situation. Thank you.
はい、ピチャモン先生ありがとうございました。今日は本当に長丁場でしたけれども、皆さんご参加いただいてありがとうございます。特に会場を貸していただいたですね、専修大学の長谷川先生、ありがとうございました。また今日、Zoom でご参加たくさんの方、150名近くですね、Zoom の方ではご参加いただいてますけれども、その Zoom もこういうふうにスムーズに運営できたのはですね、今日ご協力いただいた業者の方が来てますので、ありがとうございます。また今日通訳の方もですね、同時通訳で、ちょっといろいろなんかアドリブな発言もあった中でうまく通訳していただきましてありがとうございました。であと手話通訳の方もですね、最後まで、本当にありがとうございます。はい。で先ほど私今回大きな宿題をもらったんじゃないかということを申し上げましたけれども、やっぱこの書かれていること、国に対する勧告だったり、あるいは企業に対する勧告ではありますが、やはりこれはですね、国や企業に任せるんじゃなくて、やっぱ私たち市民社会とですね、企業と、そして国とが、みんなで協力して、一個一個、クリアしていかなければならない課題であるというふうに思います。ですので、これを機会にですね、国連からこのような専門的な観点で包括的な報告書、日本の問題点を指摘いただいたわけですので、これをしっかりと私たちとして取り組まなければならないということかと思いますので、一緒にですね、これから取り組んでいただければと思います。本日はどうもありがとうございました。最後に一言ありますが、私からの挨拶は以上で終わらせていただきます。ありがとうございます。
ありがとうございます。本日このイベントに向けてですね、非常にご尽力いただきます。先ほども紹介ありました専修大学の長谷川先生の方から一言いただければと思います。よろしくお願いします。
I'm Hiroshi Hasegawa at Senshu University. I'm a professor here, and thank you very much, Professor Yeophantong. I'm not sure if I'm pronouncing it correctly, but for the insightful and informative and impressive, thought-provoking talk. The problem with Japanese people is that we learn about human rights in school, but only that Japanese constitution guarantees human rights. That's all, period. And we never learn about or think about seriously what the actual content of human rights is in the real world. And we just learn it as an ideal slogan, and that's all. So we need efforts to really understand what human rights really mean, what it has to do with our everyday real life. And I can see, that's why I invited my students who didn't raise their hands to this lecture, because it would be useful for them. I'd like to ask you, since it seemed to me that you're an excellent instructor and a teacher of human rights, I would like to ask you to write a book on human rights, and we'd be happy to read it. And I would like to support the activities of human rights now, from now on too, because it will play an even more important role in Japan. So thank you all for coming, and thank you very much again, Professor.
どうも突然の振りにもかかわらずありがとうございました。それではですね、一応最後のアンケートのご協力を皆様お願いできればというふうに考えております。今後の運営に生かしていくようにしますので、オンラインで参加の方はこの QR コード、画面に映っております QR コードを、読み取っていただくか、もしくはURL を、個別にお送りさせていただきますので、そこから入ってください。会場の方、申し訳ありませんが、ちょっとこの遠いですけども、この QR コードを読み取っていただければ、Google フォームでアンケートに回答いただけますので、よろしくお願いします。はい、それでは、本日のプログラム、これにてすべて終了いたしました。本日はどうもありがとうございました。最後に登壇者の皆様に拍手をお願いします。ありがとうございました。